Hello, my name is Carl Keene with the Cooper Hurley Law Firm. Uh, I want to talk a little bit about the PI-1A. That's the injury report CSX provides its employees when they get injured. This is a main form that starts, your injury starts actually when you start filling this form out. You got to be careful with what you put on. It's a form that can, and most times gets people in trouble, because if you fill it out wrong and you go to a jury trial, they're going to have this thing loaded up to the side of a 4x8 sheet of plywood for everybody to be able to read it, and they're going to explain that there's a place on here that says you have a safe place to work. Well, if you had a safe place to work, you wouldn't have got hurt. So there's several questions on here, and we'll go through them. The first 10 or 12 questions is very simple. It's just, your name, your ID number, your address, your occupation, the date of the incident. Where it really starts to get difficult here is where it says describe fully how the injury occurred. And then just for an example, I'm using as a carman. While inspecting track M1, he slipped on a tie plate that was left in the yard after some track repair, falling on his right side, breaking his left arm. And the reason I filled it out like that is because if you, although we know your arm is broke, you fell on your right side, which leaves an opening for you to be able to say, well, now guess what? I went home 2 days later, my back's killing me, or my shoulder's killing me, or some other condition that's came up. So that's leaving you an opening and just saying there's just more wrong with you than your right arm, and it won't get you in trouble later on down the road. And the next question is, did a defective tool or equipment cause this injury? You can answer that yes or no. Now myself, I would have put yes and to be determined. That leaves another opening for if something came up. Say, for instance, he was working in the shop and you didn't have the right tool. You can always put to be determined, and guess what? The attorney can take it from there, and it's leaving an opening for everything. Did working conditions cause or contribute to the cause of the accident or injury? Yes, I always put yes. It was materials left in the yard after track repair. They should have came in here and cleaned and made the track more safely and respectful for people to work out, instead of, they should have kept it out of service till it got repaired. That's what a name right is. But we all know that their main concern is getting the cars put in from A to B and getting them on the road and inspected and out of the yard, and they don't really care what happens in between. There's several other questions on here that just some of them can be tricky. Was the workplace adequately lighted? Well, if it's in day shift, more likely it was. At night, let's be honest, you ain't ever got enough light in that yard. We always know that. If you're inspecting any kind of cars or anything, there's no light on lights, you're holding it. Next question, if track equipment involved, give the initials of the car and the number. That would be effective if you got hurt, while you was checking letting the handbrake off or whatever. You'd want that information. Was there any failure to give usual or necessary signals? Well, I would have put yes on that, because they shouldn't have gave you the track to work on in the first place. The track should have been out of service. And was anyone at fault? That's a question that a lot of people put on there. Well, I've even seen some people put yes, me. Well, that's not the right answer. You put yes, and then you put the railroad. The railroad's always at fault. They gave you the track to work. They gave you the equipment to work on. They give you the supplies, the safety equipment, and you still got hurt. You didn't go out that morning and intentionally get hurt. Also, we got on here body part affected. I put right arm, etc., because you don't know what's going to manifest later. Under nature of complaint, I put on there the fella The gentleman fell on his right side, breaking his right arm. And again, you don't know what's going to manifest later. You know, 1 or 2 days down the road, you can start having back problems. Yeah, you can have neck problems. You can have anything. So always leave yourself a place to go there. Was medical attention provided? Guys, I got to tell you, medical attention is number one here. When you get hurt, before you fill out any forms, you get the medical attention. If you're sitting in there in the supervisor's office and he wants you to fill this form out and you think you need medical attention, if he don't want to get you medical attention, pick your phone up and call 911. You can do that and let them come get you. You can fill this form out later, and if they get mad, who cares? Was a prescription provided? From personal experience, I'm going to tell you that the supervisors will give the attending physician a letter saying that all these here things will make it an FRA reportable injury, including any type of prescription given like for pain or suffering. But if you need that prescription for pain, go ahead and take it. We don't care if it's an FRA reportable. That's their problem, not yours. You're the one that got hurt by no fault of your own. So get the medical attention and the proper prescriptions if need be. The next one is you just put the name of the emergency room that you was taken to and describe medical first aid. You know, you had chest x-rays of your right arm, etc. Is it going to result in lost time? Well, if you broke your arm there, you know, you can't go out there, and there's no light duty out there on the railroad. We all know that. So go ahead and take your time off. Is this a reoccurrence? You know, no, it's not. It was an accident that happened. Okay, you got a couple more here and we'll be through. You got a location where it happened. You're going to put your yard office and the address if you know it. You're always also going to put any witnesses that you know, your partner, your coworker, if you went out and they picked you up on the other end of the yard and you tell them what happened. You put the witnesses down. Okay, the next one is employee signature and date. That's where you sign it. They're going to ask you to sign, the supervisor is going to ask you to sign on the bottom where it says medical information released. You do not have to sign there. If you do, they're going to go back and they're going to pull your medical records, your dental records, whatever type of records they can get. And you can't stop them because this, if you read this a little further down, it actually gives them the authority to go back and pull your records with this signature on this form. So the only place you're required to form is that it's the first section where it says employee signature. The other side's going to be your supervisor, and he's going to have to witness you signing that form. You do not have to sign the bottom. Please remember that. It'll make your case go so much smoother because we don't want them to have your medical records. They're going to go all the way back. You know, it's even a possibility if you got injured in high school and broke your leg and you happen to walk out there and injured your leg, they're going to go back and say, well, you didn't put that on your employment application and you could possibly be fired. So you wouldn't want them going back and looking at your medical records. It's none of their business. So don't sign it. Don't release it. Just sign where it says employee signature only. I hope this is very helpful. Please keep in mind, if you got any questions, please call Cooper and Hurley. We can walk you through this procedure free of charge. It don't cost nothing. We're here to help. That's what we're here for. Thank you very much and appreciate your time.